it goes before the judge, and I think you're estimating maybe November 29th to determine whether he's going to put a stay on it, what kind of stay that's going to be. Let's say he does that, and the clock starts ticking at that point, all the other litigation works out, and then he comes back, or she comes back and says, or they come back and say, you know what, we're going to let the mandate stay, and in the meantime, the clock is ticking as far as what the original order said, that people have to get their shot by. How does that play out as far as, would they extend that time frame to get us further into the first next year, or how is that even addressed in the lawsuit, if at all?
So, Senator, that would require probably a bit too much speculation on our part. We can't really be certain what the feds would do. In the OSHA preliminary injunction that circuit, once that was granted, the feds through OSHA actually took the step to back off of pursuing the rule until litigation could come to fruition, until they could get a final answer from the courts. I imagine if a PI, preliminary injunction, is granted on a CMS issue, that the federal government would probably take the same approach. As far as extending timelines for having your employees vaccinated, I'm not sure what would happen. It would seem logical that if the deadlines keep moving to the right into the courts, they would also have to give us more time to comply. But again, it's speculation. I'm not certain.
And refresh my memory, in the lawsuit or in the mandated requirement that's being challenged, did it allow for testing or for submission that you have antigen in your system, or was that even in the lawsuit? I don't remember.
So, Senator, on the CMS mandate, it's my understanding that there is not currently an option for antigen testing or weekly testing in the so
straight up down mandate on the vaccine then.
That is my understanding. It's not. Sorry.
Thank you, Mr. Chair.
Senator Flowers, you recognize for a question.
Thank you, Mr. Chair. I wanted some clarification. When you're talking about the OSHA case and the fact that there's a permanent injunction by the Fifth Circuit, that's because it's been transferred to the Sixth Circuit, is it not, and consolidated with the other cases? And as you said, they backed down for the litigation to continue in the Sixth Circuit. Is that your understanding?
So, let me make sure I understand your question. So, procedurally, yes, the cases have been consolidated to the Sixth Circuit, but no one has listed the stay or the injunctive relief that was granted by the Fifth Circuit. So that still stands as of today.
Right, but that doesn't mean that the outcome may be that there is a reversal of that permanent injunction against the rule.
That I think is a fair assessment. There is never any guarantee to litigation when you're in the court system. The Sixth Circuit could agree with the Fifth, or they could not. So, but as it stands today, the OSHA regulation has been stayed by the Fifth Circuit. They pulled down their implementation, and at this stage, I think we're in a wait-and-see approach as to what the Sixth Circuit does.
Well, I asked the question because I'm concerned that people start using the term victory and nothing has been finally resolved. Would you agree?
Depending on your viewpoint of the position, but I would say that the Fifth Circuit was a victory for the Fifth Circuit.
Senator Mark Johnson.
Thank you, Mr. Chair. Gentlemen, are you aware of the 2012 Supreme Court decision that CMS could not withhold funds from a state for not adopting Medicaid expansion under the Affordable Care Act? And does that have application to this situation?
been a number of years since I looked at that decision. Unfortunately, I think it's distinguishable. Medicaid expansion was an optional program versus what CMS is arguing now, that the mandate is a condition of participation. So I'm afraid, and without going back to the opinion of freshman, I think there would be a distinction between the two.
I don't want to get you too far in the weeds because this may have something to do with your brief. But I have a question I was going to ask Dr. Patterson. I want to ask you first. And this is not disrespectful to him at all. It's just an inquiry. Is Dr. Patterson a state employee? He can stipulate to it by nodding if he wants. There's a follow-up that clarifies why I'm asking.
I'm not trying to avoid your question, but I'm not certain, and I think that.
So you do stipulate you are a state employee. So as a state employee, Dr. Patterson would have qualified immunity in his actions, official actions. Is that correct, Mr. Foley?
That's a fair assessment, yes.
Okay. Now that's immunity if somebody follows the law. If you're a police officer and you do something that's outside the law, then your qualified immunity comes into question at that point. Is that not correct?
I think that there are several factors that would raise any state official beyond protections afforded either in any immunity situation that you all enjoy, or we enjoy as well.
But again, you enjoy that protection when you're following the law, in essence. Is that correct?
In essence, yes, sir.
Okay. Thank you very much for that. Thank you, Mr. Chairman.